Good evening, everybody. My name is Ursula Kilkelly. I'm the Head of Law here at UCC. You're all very, very welcome to this very special event. And I'd like to thank everybody who's been essential to organising and inspiring us with this event. So particularly thanks to Professor Siobhan Mullally, who's been the inspiration behind this. We're very pleased to have here not only a very distinguished guest in Shashikala Gurpur, as Dean of Symbiosis Law School, and I'll talk about in a second, but also the Ambassador Lalakesh from Dublin, the Indian Ambassador. You're very warmly welcome here. And this is you've been to UCC many times, and we're very pleased that you've taken the time to be with us this evening. I want to introduce you, though, now to Professor Shashikala Gurpur from the Law School in Pune in India. As many of you will know, Shashi has a long-standing personal as well as professional interest in both UCC law and in Cork. I didn't overlap with her in our time here. I arrived in '99. Shashi was here in the Faculty of Law before 2007. We did meet, though, at the Global Deans Forum in Singapore during the year, which ironically was the first time that we met. Shashi taught here for a number of years in leading our legal writing programme. So it's a huge pleasure to have you back here in UCC and in law. Symbiosis is widely recognised as one of India's leading law schools and has established several international law programmes in the United States, in Canada, Australia and in Europe. And we are very pleased this evening to be celebrating the beginning of the formal part of our relationship with Symbiosis. I know that you met with students earlier on who are interested in exchanging, and we're very looking forward to having your law students with us as well. I know that students from management and Symbiosis have already spent time here with Mike Murphy, who's from the Department of Management and Marketing, and it's great to see that this will extend now to law students also. It's a hugely important part of all of our development, I think, that we internationalise in this way and share experiences in as wide a range of areas as possible. So it's great that law will now have this opportunity, law students will have this opportunity. In terms of Shashi herself, holds a Ph.D. in international law from the University of Mysore in Karnataka State, and her research interests are varied: international law, human rights and intellectual property. She was awarded a Fulbright scholarship in 2011 to the United States, and also an AHRB Visiting Fellow at Edinburgh Law School in 2004. She's a former member of the Law Reform Commission of India and is the recipient of many honours and awards for her leadership in legal education in India. And I encountered that firsthand myself in the exchanges that we had in the Global Deans Forum in Singapore, where she was to the forefront really in all of the discussions about the internationalisation of legal education and progressive thinking around legal education. Again, something I think that our law schools respectively share. So I'm absolutely delighted to welcome you both here this evening. And before I ask you to take to the podium, can I just present you with a number of small gifts, both to the Ambassador and to yourself, as a mark of your visit here this evening. So Professor Gurpur is going to talk to us this evening about constitutional and human rights challenges in contemporary India, landmarks in a judicial journey. Thank you.
Good evening, Your Excellency, Mrs. Radha. My dear Dean, colleague, Dr. Usula and Shivan Mulali, my respected colleagues, my friends, friends of UCC, friends of India, a very good evening to each and every one of you. As I stand before you, I am sort of overwhelmed because I never thought in 1998 when I left that I'll come back as the Educational Ambassador of India. Because when I left as a parent, I left as a professional, because there were so many other factors which were prompting that exit from Ireland. But I went with the hope that we had worked out on a project which was to be funded by European Union on EU-India law link. I don't know how many of the colleagues, senior colleagues here will remember that. But once I reached India, things changed. The then government put a hold on the project, saying that we don't have to learn human rights from Europeans. So that was the kind of background against which my dream of continuing the link with Ireland was shattered. But we took inspiration from the experience. So Dean Caroline Fennell at that time sent a student to India. And yesterday I recalled that she had sown the seeds of internationalization much before it became a fashionable course of action for law schools in India or law schools in Ireland. So I congratulate UCC on being so far-sighted much before your other colleagues took that up elsewhere in Ireland. Now, the link with legal education in India has been pretty long for me. I started my career in a small town, my hometown in Mangalore, and then I was invited to National Law School Bangalore, which is now hailed as the premier law school in India. And my link to Ireland has been because of that shift from Mangalore to National Law School, because that's where I met Dr. Tim Murphy, an eminent legal academic, and then married him and came to Cork, and UCC was open in terms of inviting me and giving me the opportunity to teach here and to learn from the great legal education heritage that UCC had by then cultivated. But I must say that today Symbiosis is one of the top 4 law schools in the country, is because of the various experiments that I was able to contribute to because of my exposure to Ireland, among many other things. So on that count also, I thank you and congratulate you, and this is a great opportunity to use this forum to convey that sense of satisfaction, sense of gratitude, and also a kind of a hope that we will begin from here. And I should say that there is no limit that's going to be there for the possibilities that we are going to have in future. The third point I would like to raise here is that already Dr. Mulali has travelled as the representative of this institute to our law school. There will be opportunities for eminent teachers from here to come and talk to our students, share their expertise and contribute to our research agenda as much as teaching agenda. Our students are going to come here. So today we discussed a lot of possibilities with your students about how they could be benefiting from the visit of these students, or they could benefit by visiting our institute. But I would like to put on record, since our ambassador, Her Excellency Mrs. Radha is here, that it should be our attempt to recognize the law degree of UCC in India, so that a lot of students in India who want to study law, just like how students here want to study abroad, they would love to study abroad. So such students should be encouraged to pursue law degree here, or our collaboration, which we have now, should mature into another level where we produce graduates who are equally trained in India and in Ireland. So both our institutes develop competencies which are surpassing the normal way of looking at things at a very different level, at an ideal level. So that's the request and that's the hope. Now let me come to the topic. we lawyers tend to use legalese, so forgive me if somewhere I use the words which are some of the non-lawyers in the crowd. Please forgive me if you don't understand those words. I'll try to keep it as simple as possible, but sometimes, you know, when we quote judgments or when we quote laws, we may use words which are not that commonplace. I have picked up certain issues. These issues are a little bit controversial and a little bit troubling the conscience of any human mind because of the sea change that India is witnessing in last 10 years. Especially in last 3 years, India has gone through a lot of change. I would suggest that this change has been a kind of response that has happened a response to the changes that have happened in the close neighborhoods, particularly the Arab Spring. The whole mass rising in India in the name of a campaign against corruption was very much coinciding with the movement in the Middle East on, the Arab Spring. Although it did not take the violent tone of Arab Spring, the uprising was very much a kind of dissatisfaction against the way of governance. It was dissatisfaction against the way of unequal distribution, huge divides in the society. So some of the issues I have taken up are in the light of these developments, but I have been very careful because we have the representative of our country here. So I've been very careful in picking up issues which have come in the forum of Supreme Court and other high courts than looking at it from the journalistic or news interest kind of point of view. So Your Excellency, kindly consider that. I mean, somewhere I may border on being very strong in my opinion, but that doesn't mean it's individual opinion. It is very much validated in the judicial literature. So let me first of all begin with what is Indian constitutionalism and what are the challenges. So first of all, I'll introduce you to the 4 challenges that I picked up among many others. The first challenge is, which was reported as the most corrupt and the most controversial development that was picked up by the Supreme Court, that was ordered for a special investigation under the Central Bureau of Investigation in terms of unearthing the corruption, in terms of unearthing the lack of transparency, the illogical, the ad hoc manner in which the natural resources of the country, very important natural resources of the country, were allocated. The infamous coal block allocation case. The name of the case is Orissa Mining Company case. This case has been filed by the government of Orissa. Orissa is a state in the east of India, and this state is blessed with huge natural resources, but also with huge tribal population, you know, forest dwellers and people who are ecosystem people who depend on trees, animals and produce of the forest. So these tribals were dependent on these lands, and these lands were basically forest lands, and mining operations were proposed to be conducted in these forest lands by multinational companies which were having a parent company which was registered in India, Sterlite India. And the company which was behind the scene was a Korean company by name POSCO. So the case is also infamously called as a POSCO case, P-O-S-C-O. And the decision of the Supreme Court subsequently led to a kind of development whereby the whole allocation was questioned to such an extent that Supreme Court said that go and take approval from the tribal council to continue your mining operation. The case has a huge history, which I'll be elaborating later on. The history begins from 2008, when the Ministry of Environment did not give the license to this mining company to conduct mining operation, because Ministry of Environment and Forests, as it is called, had 2 jurisdictions. One is to protect the environment and to halt activities which would endanger the environment. Second is that mining operations are a strict no in areas where endangered species live or eco-sensitive areas. So Ministry of Environment and Forests is under the central government. You know, in India we have 25 states. India is a federal country. It's rather a continent, as Professor David Morgan used to say. It's not a nation as such. So each provincial government has certain powers and the central government has certain powers, which is enumerated under the Constitution. But Environment Ministry is, or environment is a matter of federal government. It's under the powers of the federal government. So Central Environmental Agency, the Ministry of Environment and Forest, did not permit these mining operations. Subsequently, they went to the court. In 2008, for the first time, it was challenged. And at that time, court allowed the Environment Ministry to reconsider this licensing based on certain conditions. For example, rehabilitation package for the tribals, the replanting. So about 15 different measures were considered, they were recommended as conditions. Subject to those conditions, Environment Ministry could consider. But Orissa Mining Company, backed by these private groups, was not happy with this, so it appealed to the Supreme Court again. Now, at that time again, the Supreme Court reiterated this point. But in the meanwhile, we have a tendency in India, it is called public interest litigation, where matters of public interest could be picked up by somebody who is not concerned with that. You know the word locus standi in law, which means only those of us who are aggrieved have a standing to question it in the court of law. But in public interest litigation phenomenon, somebody who is totally disconnected could question it, provided it is a matter of public interest. So this Orissa Mining Company, in the Orissa Mining Company instance, one of the public members, namely Manohar Lal Sharma, he instituted a public interest litigation. So by virtue of that, the public interest litigation requested the Supreme Court to go deep into the allocation of coal blocks all over the country. So they went deep into the allocation of coal blocks all over the country from the year 1993 to the year 2010. And they realized across 7 states, all these allocations were done in very arbitrary manner. They were given out to the private companies without any kind of reasonable grounds. There was no systematic, logical framework under which these decisions were taken. So the judges instructed, they rather ordered, that all these coal block allocation matters should be given to the Special Investigation Bureau. And then the issues of corruption, partisanship, favoring one particular private company, etc. should be brought to books and the concerned should be arrested. So we have seen that between these two developments, the coal mining development and the coal block allocation development and the POSCO involvement, we have seen how the judicial journey has been one of protecting the country in terms of fundamental rights of the tribals and ecosystem people, protecting environment as the common resource, and also about allocation of coal mining in terms of arbitrary, unreasonable, ad hoc allocation have been re-investigated. So this is one issue I would like to focus on, the two different issues but connected. The second issue is the recent news item. I do not know if you have watched BBC recasting it again and again. The landslide in a village near Pune, in Mallen village, overnight during the height of the monsoon, more than 150 people died because of the landslide. Now, why did people build houses in the hill base is the first question. Second is, weren't the hills there? They always say that hills are as old as, or whenever you're saying something that it is old, you say that these are as old as hills. Means hills are supposed to be resisting most of the natural changes. Then how could such a landslide happen in Mallen? Investigators, at that time, some of the journalistic investigations projected that Mallen landslide was not an act of God. In law we have a phrase, if it is act of God, nobody is liable, and you have to only look at it as an issue to be addressed as a crisis. But in Mallen Hill case, it was realized that because the slopes were flattened as part of a kind of governmental project, suddenly they were flattened and about 300,000 varieties of trees were felled. Although official figures show 28,000 trees, the holding capacity of the soil was affected during monsoon, because of which there was a sudden landslide, and all those poorer people, usually poor people live in such areas, so the poor people who lived in these areas were killed overnight because of this landslide. So whether disasters are human-made or are they act of God was the primary question that was asked in the Mallen landslide case. Of course, it did not go to the court of law because we have a National Disaster Management Plan. National Disaster Management Plan talks about disaster prevention and disaster management. But how to predict the disaster? How do you keep a watch on the disaster? Especially when you're doing planning and you're taking up activities with total obliviousness to the consequences of that, even though you have reports from National Geographic Survey which discouraged from flattening of the slopes, you just ignored that and you went ahead, and then what happens is Mallen. So this is the third example. The last example I want to highlight, and a lot of issues are there, within the limited time it's difficult to cover, so I would just touch upon it, is Article 21 of the Constitution. Indian Constitution's Article 21 says that it is worded in a negative way. Nobody shall be deprived of life and liberty unless according to due process of law or according to law. Okay. Now, life and liberty as sacred, protected by law, not to be deprived, is one principle. But on the other hand, how to protect life and liberty, these aspects of Article 21 have had ever expanding horizons ever since 70s. So we had the very first case of Maneka Gandhi, where Maneka Gandhi was permitted to go abroad against orders of the government, because life also includes right to move abroad. So there were so many other dimensions read into it which I am going to highlight as I move further. I hope I have been clear till now in terms of introducing the issues. Now, against this background, let's look at the constitutionalism of India in a very simple way. Constitutionalism. By constitutionalism, we mean processes and procedures in terms of the constitutional principles and safeguards and provisions. So, Indian constitutionalism has a strong balance in favor of natural law, in terms of what ought to be done, in terms of the higher morality, rather than positivism. Not that we are not positivist, we had a very strong positivist inheritance from the colonial rulers who brought in so many legislations prohibiting something, facilitating something. So we are also into the tradition of legislating on everything. But as far as our inherent dharma, in the sense dharma is something that is prevalent as a philosophy, whether you are a judge, you are a teacher, or a lawyer, or a politician. So prevalence of dharma as the hallmark of oldest civilization seems to be guiding our constitutionalism. Now, what is this dharma? Dharma, if you go deep into it, there is no one definition of dharma. If you go to the root verb of dharma, it is dhra. Dhra means to sustain. So dharma is a set of principles which sustain you. So how to be dharmic, or how do you sustain dharma? There is no question of a certain dose of your behavior being in accordance with dharma. You have to be inundated with dharma. I mean, it is a kind of non-dualistic, it's a kind of total it's not shades of dharma that is expected when you are behaving according to dharma. It is not a small dose of dharma. It is inundating, getting inundated with dharma, which means that everything that you do, anything that you do should be in accordance with dharma. So from that point of view, dharma, or as Buddha said, the dhamma, are hallmarks of justice, peace, equality, equilibrium. So from that point of view, if you see, Indian constitutionalism had its past in terms of positivism being injected through various regulations of the colonial masters, and subsequently we had so many judgments in administrative law, in constitutional law, highlighting the idea of rule of law, authority, mutual check and balances between the three arms of the state, namely executive, legislature and judiciary. But then our constitutionalism, from time and again, through the court pronouncements and through our amendment practices, has shown that it repels authoritarianism. We underwent a very eclipsed stage of evolution of our constitutional existence in the emergency period in the mid-70s. But we came out of it unscathed, because all the amendments which were done to concentrate the authority were undone by subsequent amendments. So we have always repelled authoritarianism as a constitutional community. Within the Constitution, we have Part 3, which has got fundamental rights, which is very similar to the Bill of Rights provisions in various constitutions. We have Part 4, which we have borrowed from Irish Constitution, namely Directive Principles of State Policy, which are like the directives to the state. And we have Part 4A, which has been introduced through an amendment later on, which talks about fundamental duties. But the interesting point is, Part 3 does not rest on its power. It borrows constantly from Part 4. Part 4 is something that cannot be questioned in the court of law. For example, in Part 3 we have the freedoms and we have the liberties. I mean, if you create a hierarchy among the freedoms, if I can give you an overview, Article 13, Article 14, Article 15 talk about equality and non-discrimination, and equality before the law and non-discrimination on the basis of any of the grounds such as race, sex, place of birth, descent, origin. So it is right to equality. And then Article 17 talks about right against exploitation. Article 19 talks about various freedoms. Freedoms would include freedom of speech and expression, freedom of movement, freedom of trade and profession, so on and so forth. Then Article 20 speaks about protection and safeguards against the operation of the law. For example, your right, in case you are arrested, what are the rights? Your right not to be tried twice for the same offence. Your right to be protected by the fair trial, like principles of natural justice to be followed. So, as you move, in terms of hierarchy of rights, you go to this important article, namely Article 21, which is right to life. And right to life inherently talks about right and liberty together. So, if you were to put a hierarchy of rights, right to life is on top and rest of the rights neatly arrange themselves. But the judicial journey through these constitutional provisions has rendered such a situation that right to life has been expanded further. Its horizons have been pushed to include otherwise non-enforceable principles of Part 4. For example, right to education has been introduced as a fundamental right in case of children below the age of 14, free and compulsory education. Part 4 of the Constitution under directive principles was speaking about it as one of the principles, as a directive to the state. But when it became amended in terms of becoming part of Part 3, it was Article 21A, free and compulsory education for all children. So, in terms of state's responsibility, Part 4 would be giving it a kind of ideal kind of status, as a kind of goal to be achieved by the state. So it is in a way it is non-justiciable. Nobody can question it in the court of law to enforce those rights. But when it shifts itself, when it is pulled out of that and brought into being part of Article 21, Article 21 is the most sacrosanct article. And in the post-emergency period we have had judicial debates whereby in one of the judgments the judges have laid out the basic structure of the Constitution. Under no circumstances you could touch the basic structure of the Constitution. So right to life is an indivisible part of the basic structure of the Constitution. So the moment all these rights are brought into Article 21, then those rights assume the highest significance. So that is the development that we have seen, that by these ways Part 3, Part 4 have had that eternal kind of mutual engagement, and Part 4 has been brought into Part 3. It has enriched Part 3 so that many of the goals which are aspirational have been made practical, achievable rights in Part 3. Now, if you look at constitutionalism in terms of how it is there in the Constitution through various parts, I would like to posit before you the principle of rule of law, as I already told you, in terms of principles of equality from Article 14 to 16, and then you have the judicial review, then you have the separation of powers, checks and balances between various organs of the state, powers of amending the Constitution, and then the basic structure of the Constitution, and then the subsequent development of expanding human rights paradigm within Article 21. So, I want to give you just a bird's eye view of how Article 21 has expanded through various judgments. In terms of right to education being the latest, it was not only through the judgment, but it was an addendum to Article 21, 21A. So by that, there was a forcible kind of guidelines issued even to the private schools to admit children from poorer classes of the society. So the private schools said that this is counterproductive in terms of Article 19, which talks about freedom of trade and profession. So they made a small group and they went to the court. They tried to bring a stay order against the operation of this article. But that is an unsuccessful attempt because local authorities and the provincial governments are trying to implement this part of the commitment to the Constitution. Now, second right which has come about is right to privacy. We have come across number of judgments. The most significant judgment which came in this era on right to privacy was the Nance Foundation judgment from the Delhi High Court, which said that it is the high time to decriminalize homosexuality. Because in India, sodomy is a crime. It is the kind of old British law that we have. So by Nance Foundation's litigation, Nance Foundation is a non-governmental organization which works for the AIDS victims and the work of LGBT community. So Nance Foundation's argument was honored in the Delhi High Court. However, the Supreme Court, it did not turn down the content of the case. It just said that the court cannot legislate when there is a legislative vacuum. So Supreme Court has been very smart in not touching upon the issue, because the issue is the issue of fundamental rights, the issue of right to privacy. So right to privacy has been read into Article 21 in a number of cases. Even the telephone tapping case, you know, telephones were tapped at one time during, just like how you have the Watergate scandal, we had many Watergate scandals in India. So telephone tapping in terms of political leaders and others were questioned. So in those cases also, right to privacy has been the basis on which telephone tapping has been declared as a wrongful act. Then we have children's rights, a number of cases. Public interest litigation filed by this famous activist called MC Mehta, activist lawyer. Mainly his cases have been on environmental issues, but he filed one particular case which is very relevant today. Why I am saying it is, this is the case about the children who are struggling as child labor in the fireworks factories down south in Madras area. This area is called Sivakasi. In Sivakasi there are hundreds of these factories, and these factories manufacture fireworks which are exported, which are sent all over India, and Diwali is one of the main occasions when these fireworks are used. So MC Mehta did an extensive study on the plight of these children. I've got a documentary with me. Some of you, particularly law students, if you have access to Siobhan or the Dean, you could take a look at that film. It is made by an NGO which has worked closely with these firework factory children. And recently also there was a fire incident. Last year also there was a fire incident. Most of the time children get killed because they are the ones who work there. So MC Mehta made an extensive study and he presented before the Supreme Court in MC Mehta versus Union of India, a series of cases, but this particular case was on Sivakasi fireworks factory. He showed how the children were not paid wages. Of course, it is a very catch-22 situation. First of all, child labor is illegal, but child labor is regulated if the child is above 14 years of age. Legal age of children is also a kind of varied provision. In some laws, legal age of children is below 18, in some laws it is below 16, in some it is below 14. There is no uniform provision. But as far as labor law is concerned, there is one provision in Factories Act which says that if the worker is above 14, below 14 years, then that means that you are indirectly regulating it, you are not banning it, you know. So if the labor worker is below 14 years, that worker should not be made to work for more than 4 hours at a stretch, and then there should be 1 hour of rest. So Mehta pointed out that all these existing provisions were totally violated. So there is a need for intervention of the government and to liberate these children and to rehabilitate them. So the issue was brought before the Supreme Court, and the Supreme Court gave a guideline to the Madras government at that time. But what we see today is the condition has improved a lot, but the employers somehow find a way of escaping, you know. So fulfillment or compliance of the judgment has not been so encouraging. Although a lot of non-governmental organizations are working behind the scene to see that children are protected, their educational rights are taken care of, their health issues are taken care of. You know, in these factories, children work with most poisonous substances. In that documentary, you will see that when you are manufacturing fireworks, they are not giving them any gloves or anything, and these are tender hands. So when they are wrapping these explosive substances, they use a lot of papers. So how do you wrap them? With gum. So children are sometimes so hungry, they come from such poor backgrounds that they may end up swallowing these gums when they are very hungry. And in the young age, the metabolism is also high, so they tend to be very hungry. But the documentary shows that when some of these cruel employers noticed this, they started mixing some chemical with the gum, which ended up children getting sick. So this is the extent to which the ill treatment of children was continuing, which Mehta clearly pointed out in the case. Now, apart from this, there were a number of cases, Mehta cases only, on right to pollution-free air and water, where the sewage of certain fertilizer factory was being released into the river in the northern part of India. It was challenged by Mr. Mehta, so Supreme Court issued an order to prevent, to stop such sewage water being released to the river. So rights of under trials also have been clearly stated in some of the cases. D.D. Basu case, we have the famous D.K. Basu guidelines issued to the police, right not to be killed in custody, right to be protected as under trials, right to go abroad in Maneka Gandhi case, right to health is another right which has been considered as part of right to life. So two important phenomena we notice in the constitutionalism of India. One is sacrosanctness of Part 3, fundamental rights, and particularly right to life and its ever-expanding nature. Second is importing of directive principles to expand Article 21 and thereby guarantee the citizens' rights protection. Now, what I show here is not only that, international law is also a part of constitutionalism in India. The way the international law principles have been adopted, I mean, there are articles in the constitution, but in practice, our judiciary has adopted a lot of principles from international law and international human rights law in particular, which has evolved the whole jurisprudence of remedying the situations of human rights violation. I'll quickly give you an insight on Nilapati Behra case, once again reported from Odisha, where her son was nabbed under the suspicion of theft, and the next day his body was found on the railway track, so in a degenerated condition. So it was obviously a case of custodial death because he was picked up and nobody knew where he was, and next day his body was found on the train track. So while giving this decision, Supreme Court drew its rationale. Giving this decision, Supreme Court said that state should compensate, and while drawing the rationale for the amount of compensation, Supreme Court relied on international covenant on civil and political rights and also socio-economic and cultural rights. Because he was the only child of that mother, he was the only earning member, and how the mother would be deprived of socio-economic rights. So for the first time, socio-economic rights covenant was mentioned as part of the judgment. So here we see that usually judges shy away from directly implementing principles of international law because India is a dualist country. By dualist, technically I mean international law on its own cannot apply to our law as part of the law like in UK or US. International law has to be made into a legislation. But in this case, judges drew on the principles and do a sort of judicial legislation. Of course, they surpassed their power of interpretation. But it resulted in a lot of good in terms of custodial deaths, resulting in serious judicial, warranting serious judicial attention. The second important case is the famous Vishaka case, the case on sexual harassment at workplace, against women at workplace. And in this case, for the first time, Justice Verma, the great judge that he was, drew on the principles once again of covenant on socio-economic and political rights, and he said how sexual harassment at workplace will deprive the basic right of women in terms of living with dignity, in participating in workforce and economic freedom. So as a result, today you see, just in December we passed a law, the Act on Prevention of Sexual Harassment Against Women at Workplace. So what was given as guideline in 1997 in the Vishaka case, which some of us immediately implemented in our universities and institutes, some didn't because it had a wide import in terms of state and non-state. But some of the industries were foisted with sexual harassment litigations, For example, the famous IT company was also encountering litigation because of this. So we saw that there was a lot of development coming forth because of this monistic treatment of international law, means directly incorporating principles of international law in judgments. However, there was one particular judgment which was much before Vishaka, where the court said that directly we cannot interpret the treaty because we are only a judiciary, and they refused to blacklist the cricketers who were playing for the Kerry Packer series. I do not know how many of you know about the Kerry Packer series. Kerry Packer series are the kind of understanding or agreements in cricket where people who would play for the Kerry Packer series would have links with South Africa. And at that time, South Africa, under the Gleneagles Treaty banning racial prejudice, was blacklisted. Anybody who had links with South Africa was blacklisted from playing elsewhere. So 2 players who came to India to play as part of the team were associated with the Kerry Packer series. So one of the members of the public filed a case in the Bangalore High Court based on the Gleneagles Treaty to ban these players. But the court refused to do this by saying that the court has only an interpretative power and not implementation of the treaty. So you have such exceptional examples of courts refusing to implement international law, but on very crucial issues of right to life and socio-economic rights, you have seen how the courts have upheld the principles of international law as part of constitutionalism. Now, one of the human rights issues that is very much prevalent in discussions in India is the corruption issue, because of the Transparency International survey projecting India in a very bad light, particularly the bureaucracy of India. So the magnitude of corruption is mentioned in various surveys of Transparency International. You could see it on the website. Subsequently, we had a development of 2G spectrum, where once again the allocation, the procurement policies of the government, as I told you already, in terms of being arbitrary, ad hoc, favoritism, nepotism. So these were the issues in terms of this 2G spectrum. So the Supreme Court, sorry, there is a spelling error. Supreme Court went forward to cancel the licenses which were given in favor of one particular company. Once again, a lot of underdealing and undercutting and corruption were there. The next one is about Citizens' Charter in terms of getting services from the government structure. This was projected by this mass movement which was led by a few activists and a mass leader, Nahazari, and they were looking at getting a very strong Lokpal bill. By Lokpal we mean ombudsman, an ombudsman who would be entertaining complaints of non-deliverance of service by the governance bodies and then intervening there and also dealing with corruption cases. However, now India has moved forward with the new government. The Jan Lokpal concept might come in. By Jan Lokpal, Jan means people, people's ombudsman, where we won't restrict it to the governmental officials and ministry related bodies. There will be representatives from non-governmental organizations, there will be representatives from citizens activism. So that is the bill which is proposed by these activists. So we see a likelihood of that bill being accepted in due course. So we have hope for that. Now the other one is a very important issue. Yesterday, same activist gave a call. His name is Anna Hazare. He is a Gandhian. He hails from Maharashtra. He gave a clarion call to the Prime Minister that now you should be looking at getting the black money stashed abroad by rich Indians by using them as tax havens, hoodwinking the tax authorities of India back to India. Because this movement was started by our Professor Emeritus Ram Jethmalani by filing a petition in the Supreme Court that this money, if it is brought back to India, every average Indian will get so much money to his or her credit. So this campaign was very much one of the points of manifesto in the recent election, that black money will be brought back to India. Although Swiss government has been cooperating, we will have to wait and see how far it is going to be a reality. So this is a much debated issue, and all these corruption issues have a connection to human rights, as you would agree with me, because human rights violation in terms of governance, in terms of resources, etc., happen because of the connivance of corrupt agents. Now the other issue is human rights in private sector, very important issue. I also represent private sector. In India we have a lot of large corporations operating, and some do not operate in the form of a corporation but a non-corporate association. Their growth has been phenomenal with the liberalization and globalization happening. So there is this hire and fire kind of policy, fly-by-night operators coming and opening their shops, employing people and just giving pink slips. So security of employment, etc. So the new government is looking at ensuring the security by new labor code. It is under discussion. But what I would like to highlight is the John Ruggie report, where it talks about complying with the human rights framework. And Philip Alston has also written about it way back in 2005 about certain benchmarks of human rights dimensions coming into private sector in terms of human resource development, compliances to the regulations. So we have this new provision of corporate social responsibility. Some of those dealing with corporate governance would be familiar with this. Now, when the corporates operate, it could be in the way they govern themselves, or it could be in the way that their products or services would be reaching people. How far are they protecting fundamental rights? In India, we have had a very important judgment coming from Delhi High Court, where compulsory licenses issues in case of mass drugs, particularly those which relate to cancer drugs, was discussed, and they said they did not look at the case as purely case of intellectual property right, but the impact of that license on the fundamental right to life in terms of right to health. So they said, they cancelled the license, and they said that this should be available for compulsory licensing and available at discounted price. As a result, company will get a serious hit. India will become an unpopular destination for such multinational pharmaceutical companies. But the court, in one stroke of pen, was able to bring justice in terms of poorer patients who could not afford this cancer treatment. So this is what we see in terms of private sector's operation and judicial impact. So it is court which has reminded this profit logic of the corporates to be moderated, toned down by the issues of ethics and justice. Now, the two most important issues that all of you would be recognizing India for. Secularism is identified as India's national characteristic. Now, what do we mean by secularism? I should use the word secularism in inverted commas, because in India, secularism is mentioned in the preamble. It was introduced by Constitutional 42nd Amendment in 1976. But what is this secularism? Nowhere it is defined, nowhere it is mentioned. You will have to understand it from the articles of the Constitution, which range from Article 24 to about Article 29, which talk about freedom of religion. In Article 24, the freedom of religion is defined as right to profess, practice and propagate religion of one's choice. Now, this is where the whole controversy comes in, because is secularism, and there is also a provision which says that all religions will be treated equally. No religion shall be official religion of India. No religion shall be given preferential treatment. Minorities shall have the rights to run their educational institution. They shall have the right to protect their culture and language. So this is how 24 to 29 you will see the whole plethora of rights related to religion, touching upon practice of religion. Now, the definition is missing. The philosophy is clear in the preamble, but the controversies have erupted. Secularism is also declared as one of the basic structures of the Constitution, from which no deviation is permitted in amendment or in the operation of the Constitution. Now, I'll give you an interesting case. Students belonging to the faith of Jehovah's Witness in the state of Kerala refused to sing the national anthem. When the children refused to sing the national anthem, children were dismissed from the school. The decision was questioned in the court of law. In the court of law, at the High Court level in Kerala, it was clearly told that this is clearly disrespect to the national anthem, to the symbols of nationalism. So, one of the violations of fundamental duties, so the dismissal was upheld. But when it went to Supreme Court, the Supreme Court went through the whole behavior of the students and the evidences and the records, and it said that the reason for refusal to pray was because in their faith, singing praise of anyone other than Jehovah was against the tenet of that faith. So they could not sing national anthem because it was singing praise of somebody other than Jehovah. So it's against their faith. But the children did not disrespect by uttering anything against the nation or national symbol. But the children, what did they do? They just remained silent. So Supreme Court said that right to freedom of speech and expression also includes right to silence. Right to faith also includes right to be silent. The fact that they did not disrespect others' faith, the fact that they just asserted their faith, does not mean it is disrespectfulness to the national anthem. So, the national anthem case shows the broad shoulders, that the Indian culture has exhibited through the expressions of its judiciary. We have had many other cases, media censorship cases in many films, where the Supreme Court has been more than liberal in terms of allowing such various expressions of different faiths and different thinking, different kinds of ideologies. So that way, if you see, Indian secularism is about respecting all differences, treating everybody equally, respecting the minorities and treating minorities in terms of preserving their culture and advancement of their faith system. Now, slowly in India, this kind of secularism is being critically questioned. One of the ways in which it has been critically questioned is in terms of faiths being questioned in terms of, the local councils, the cultural councils. We have had the honor killing concept coming in some communities, where if you marry against the community's rules or regulations in terms of marriage, sometimes outside the caste, then to protect the honor of the family, you may not be allowed to, you may not only be permitted to marry, but you might be killed. So this honor killing came before the Law Reform Commission, where I was a member. So we looked at honor killing, we wanted to diffuse the religion character of honor killing. So we showed it as a kind of unlawful kind of murders. So if you take out that cultural character out of it, then you are reducing it to an unlawful act. As long as the cultural character is there, it is very difficult to tackle that. So we made a very neutral law. So religious neutrality or faith neutrality is something that could be a kind of solution to this kind of complex problems of secularism. The other one is this infamous term, the love jihad, which was a much controversial term, or the Romeo jihad. This was questioned in a case in Kerala, where there was a report of a Muslim boy abducting a Hindu girl in the southern part of India and later forcing her to marry and then converting her in one of the religious institutions. This case was brought before the Kerala High Court, and the Kerala High Court made an elaborate observation on this kind of a trend and asked the police officers to report. The police officers in the region reported that although there are such activities, they have nothing to do with the religion. It is a simple act of misusing faithful relationship of boy and girl for the purposes of human trafficking. So it was an offense of human trafficking and not love jihad. So secularism many a times could have such controversial undertones. One of the most controversial undertones is right to conversion. Under no way, if you have right to profess, practice and propagate a religion, religions which believe in proselytization will go ahead in propagating. So when they propagate, means when they encourage conversion, conversion is not per se prohibited under Indian law, but conversion by allurement or threat is prohibited. So that was how a lot of controversies under secularism concept of constitution were brought about and debated in public spaces. So the last issue that I would just touch within the limits of time, I think I have 5 minutes, is the last issue is the challenges and the changes that family is undergoing in India in particularly in last 20 years. First of all, with the liberalization and globalization and the IT boom and a large percentage of Indian workforce getting into technological workforce and preferring to live outside India, because most of the Indians feel living in Europe, living in America is a better quality of life because you have very few people there, not so much crowd, good quality of life. So there are a lot of globalizing families. Migration has been on the upward trend. We also have a tendency where non-resident Indians come back seeking hands of Indian girls who are based in India, or they marry girls who are from the community which is available in the country where they are non-resident Indians. The problem with the cases of non-resident Indians coming and marrying from India has been a big problem, which is, you can see that on the website of National Women's Commission of India, where NRI marriages themselves became a huge headache for the National Women's Commission, because large number of girls were left in the lurch. They were not helped to go back to India. Husbands did not take care of them. Some of them committed suicide abroad. Some of them were forcibly sent back, maybe because they don't adjust, or maybe because they were traumatized by the loneliness and adjusting to a highly industrialized society when they come from the villages of, particularly from Punjab and Haryana and Andhra Pradesh. These cases were reported. So this case strongly revealed the need for a global code on marriage or global convention on marriage. The fate of the children is no good, because if there is a marital conflict breaking up, then the child custody, the international migration of the children, etc. These are all unsettled issues, and India, having a large migrant population, will have to be open to this idea of mooting a convention at the global level. The second issue is 498A, once again very much connected to NRI marriages. Most of the Indians, non-resident Indians who have taken wives from India and gone there, ill-treated their wife, the family of the girl would have used 498A under Indian Penal Code to file a cruelty case, dowry harassment case. And under this law, it is non-bailable, non-cognizable. So as a result, the person could be arrested from the country where they are. However, a lot of the girls have made use of this provision as a weapon to advance their cause, because anyway they are losers in this kind of a marital conflict. So they would have used this provision to get a kind of fair settlement or compromise. But then the way the provision was abused by some of the urban dwellers, highly educated girls, now every woman who is making use of this provision is looked at with a lot of suspicion. So I would like to highlight here a kind of biased judgment from the Supreme Court in the recent months, Arnesh Kumar case, where one of the controversial judges said that 498A is more of a weapon than a shield, and the girls have been frivolously using this section. So it's very sad that a provision which is supposed to stall the dowry death rates is being accused of being misused. So this is one issue. Other than this, the foreign judgments of divorce, the enforcement issue. We don't have a treaty by which foreign judgments have to be enforced. So a man who takes an Indian wife, goes abroad, and then she lives in India, he divorces her from there, but that and then he doesn't bother to come back to India. He would have taken another wife there. When this divorce decree is to be enforced in India, then she would have the right to maintenance, or she would have the right for custody, she would have the right for remarriage. But because that divorce decree is not recognized in India, there is no structured provision by which such divorce decrees or foreign judgments could be enforced. We have a lot of issues. Now we have some treaties by which certain nations' judgments could be enforced, but not in those areas where predominantly married NRIs live. So this is a major issue. Then we have some changes, like for example, same-sex marriages have been a possibility in India in the cultural sense, if not in the, there is no open prohibition, there is no open permission. So a vague area of law. So same-sex arrangements do exist. Live-in relationship has been discussed in the Veluswamy case by Supreme Court, where it puts certain tests. One of the tests is that couple will have to hold out as couple, and then they will have to have some kind of majority, the competence means they would have to be above 18 years of age, etc. All those eligibility conditions. But the problem came in the subsequent case, in the Indra Sharma case, where they said that mere cohabitation in itself cannot be the criterion for determining the claim of the wife for maintenance. It has to be going through the Veluswamy test, plus if the woman lives with this man knowing that he is a married man and he has a wife and children, then she is committing intentional tort. This judgment came just 1 month ago, and it said that in that case she is committing violation against the wife and children of that man. This kind of interpretation of intentional tort is a very novel kind of concept that has come into the family law field. So this is debated a lot, and finally, we feel those who debate these issues in terms of changing nature of family and changing nature of family law, we feel that probably courts are not the right fora to discuss family. Probably it is a high time to remove family from the judiciary and then bring it to clinics, because if it is a question of welfare of children, welfare of women, human rights of children, probably it is not courts, but it is a larger body of experts who will have the teeth of law in terms of enforcement of their decisions, will have to be addressing this. So India, which holds on to the ideal of family, has to realize slowly that family as an institution, if it is to be protected, then it has to be treated in a very expertise-based, in a very clinical manner, rather than in a adversarial judicial manner. So these are some of the challenges that I spoke about. Now, From all these decisions, what you gather is how judiciary has been a trendsetter, how judiciary has thought differently. Judiciary has been a kind of migraine to the governance in last 4 or 5 years. So what does the governance do? As soon as the new government, the previous government itself begins this process of judicial accountability bill, whereby it wants to interfere with the appointment of judges, it wants to regulate the behavior of judges, it wants to install a process of performance appraisal for judges. Because hitherto judges had a very secretive system, which was collegial system, the system of collegium. So the judges themselves will decide who should be promoted, who should be appointed, who should be made, given new role, etc. So for the first time you see that government of India, the central government in India made an attempt to bring this bill, and this bill was pending in the parliament with a lot of discussion because we had a rainbow coalition earlier. So now we have a majority government. So the majority government went further. So it is splitting this bill into different parts, and it has now taken only one part, namely the appointment part. Oversight on the judges, ensuring independence, looking at their performance, etc. is not the concern as of now of the new government, but it is going to reach there. So older judicial accountability bill is only addressed in terms of appointments, and in the appointment council the new government has put Prime Minister as one of the members with the veto power. So we see how even judiciary is being interfered with. In one way I agree with the logic of the government, because judiciary's collegial system has not been transparent either, even though judiciary is supposed to be upholding truth and transparency and accountability. It has not done it in last few years. So probably it is the requirement of the time. But the flip side is that it might take away the autonomy of the judiciary, because it is, they say that when the governance is weak, it is judiciary which gets stronger. So now the judiciary has been stronger, so the governance has to clip its wings. So that's what we are seeing. So now with the popular government and leadership, which talks about minimum government and maximum governance, and the strong dissidence by jurists, the fate of this act hangs in uncertainty. Whereas the reforms are full swing. So what we see now in the overall analysis is that constitutionalism, which is supposed to subdue power and authority before the majoritarian as well as minoritarian view, has to go strictly within the scope and limitation of the current sense of norm and condition of the society. Is it going there? From the analysis it's clear that it is going there. But where else it could go, we will have to wait and see. Thank you very much for your attention.
Thank you very much for what was a really excellent insight into not only the traditions of constitutionalism in India and the legal system, but also the very current challenges and trends, many of which are familiar to those of us who know very little about the Indian constitution tradition. Very, very similar concerns and challenges, not least the one that you finished with, where you are some way, I think, ahead of where our thinking is nationally on accountability and of the judiciary. So lots of really interesting topics. Are you able to take some questions? I think there will be, I'm sure, some questions from the audience people want to ask them. Mike?
Yeah, sure.
Yeah.
Very interesting, actually. I'm not a lawyer at all, but I still find it fascinating. One thing I've always wondered, it strikes me, just having spent time in India, that a lot of social order is enforced, if you like, or controlled at a local level, rather than people taking recourse to the law maybe they couldn't afford to, or the mechanisms in there. And one thing that's also interesting to me is this idea of the panchayat in villages, where you've got the panchayat, the village elders. What are the legal status there? Because I understand they're quite powerful, and they, have laws, and they punish people, and they can take people's liberty. And are they legal? Or
it's a very good question. If we are talking in terms of jurisprudence, these would qualify as alternative dispute resolution mechanism, which are similar to our mechanism of conciliation or mediation, or two rolled into one. More of arbitration and mediation, what we call MEDAR kind of organization. But the flip side is that if these members are not trained, basically if they are supposed to be guided by what we say divine wisdom. dharma. But if these members tend to act from the selfish point of view, then the disaster happens. Upendra Bakshi has done extensive study on the tribal panchayats in Gujarat, and he has noticed the negative side of this. I have done 1 or 2 field work activities time and again in 10-15 years period with one tribal group which is considered as a primitive link between the modern tribes and barbaric tribes of the past. What I saw was basically these tribes are very dependent on each other. They want to keep the community coherence. They can't eliminate anyone, excommunicate anyone. So the threat of excommunication works very well in these communities. So there they have their mechanism of resolving disputes so that within themselves, so that they always function together. But the negative side is, I had seen one case where a lady was accused of adultery, and chief of the group, chief of the panchayat, summons her, and then there is discussion, and then he says, for the punishment for your act of committing adultery is that you come and spend 2 nights in my house. So this is subjective justice, you know. So this was brought to the attention of the NGO which I was working with, which was funded by Oxfam. So we invited that chief and we tried to find out where he was coming from. We convinced him that what he was doing was not justice. So panchayats cannot be passed off as ideal institutions of justice. We need to take them with a pinch of salt. We have to apply principles of human rights, as we say in our classic argument that nothing which doesn't pass the test of constitutionalism or human rights can be upheld. I request all of you to go to YouTube and watch this film called KHAP, K-H-A-P. It is about the KHAP panchayats which are prevalent in Haryana, where honor killings are very common. So the film is a little dramatized version of the real story that happened there. The girl and the boy who belong to the same Gotra. Gotra is the genealogical stock in a community. They are not supposed to marry as per the tradition. So these two fell in love and they decide to marry. So how they were prevented from marrying, and they were chased to Delhi when they run away and try to settle in Delhi, and there were the murder attempts will be done on the boy and the girl. So it's a very agonizing story. So panchayats, positive side of panchayats is that if it is a panchayat which is led by a very good leader who is if not literate, who is guided by the real principles of justice and good sense, then the panchayats can do wonders. We have seen some villages, like in our own village, we had a tradition of panchayats for generations together. Not a single case would go to the court. We wouldn't allow any case to go to the court. Not a single injustice. We have seen cases where family would be, from my own family I have seen, the family there was a property dispute, and in that area the tradition has it that women inherit the right to property. So there was this particular woman whose husband had deserted her, and she was living with her joint family, 4 or 5 lineage of people together. So the panchayat person said that she should get the biggest share because she has no one to support. So when they were dividing, like let us say 1/6, 1/4, 1/3 or something like that, she got 30% more than others. So such things also are there in panchayats, where they have their fair sense of fairness and conscience operating. But that is an exception rather than rule. So panchayats need to be tested against the acid test of constitutionalism and human rights. It's not to impose our hegemonic idea, but it is to cleanse them. We did that with many tribal panchayats. We did gender conscientization, we did human rights conscientization. So there was a lot of change after that in the way they dispensed justice. So justice said, see, instead of imposing the court system on them, because the courts are clogged with cases. The backlog in India, according to Vivek Debroy's analysis, will take at least 35 years to clear at this rate. So today's case, if it has to wait for 35 years, what is the value of that cause of action or remedy? So it is better we create such alternative remedies, but then those alternative remedies should not be doing disservice to justice. That's very important. Yeah, thank you.
Thanks.
Any other question, please? Yeah, please. Yeah, there are many hands.
My question, like you spoke about children's rights.
Yeah.
My question is somewhat related to the women's rights in India. You spoke about section 498A that talks talks about like it's a weapon more than a shield.
That's what Supreme Court told, not me.
Yeah.
I know, I have got cases and I've seen.
Still, even though we have that section as protection for women and stuff, but still there are rapes going on in India after the 16 December case, and recently there was the Dholapur case and then the Mumbai rape case. Why is it like that? Why the culprits are not scared of the consequences, even though we have such strong laws? Is that there are lacunas in our statutes, or our judiciary is inefficient?
Very good question. No, first of all, your idea, please be seated. Idea of 498A, when I was sitting, I was a member of the commission. 498A was, I'm very sorry to say that the judge who qualified to be the judge of the International Court of Justice in a particular case, he made an observation that 498A is being misused, and but he also said in the same breath that although number of dowry deaths are increasing, so it was a kind of oxymoronic line. So there was a kind of a strong opinion in the commission that 498A should be liberalized, it should be made bailable, it should be made cognizable. So in a commission of 10 members, I was the only woman member, rest 9 male members, and more than 6 members among the men tried to say that women are misusing, I have this case, I have that case, so personal examples. But 2 members who trained under the same teacher, Dr. Madhav Menon, they were with me, and they said that, practicing lawyers in Supreme Court. So we 3 were together and we did a lot of analysis. We did the public, we sent out questionnaires to public. The commission also announced on the website, maximum number of people who responded to the questionnaire on the website were disgruntled men who had all the time on earth to respond, So they wrote that 498A is being abused and it should be made bailable. But the opinions we collected were from various segments of the society who knew the law students, lawyers, then other members of the community, activists. So the commission said that the website responses, when they did the analysis, statistical analysis, out of 365 responses, 300 responses were for removing 498A from being non-bailable. Then, in our case, 80% of the responses were asking no change. So, there was a vehement argument. The main contention on the side of those who were against 498A was very, very frivolous. They said it is being misused. We asked, what about the disuse? What about those women who don't use 498A? One, because they don't have the economic resources. Second, because they don't have the awareness. Third, because they are scared of consequences on their children. Fourth, because their family is not supporting them, because there is another girl to be married in the house, and in a household where one girl goes to the court, the other girl doesn't get suitors. So how do we answer these questions? And then we pointed out to the Ministry of Social Justice and Women's Empowerment, talking about how any tinkering with 498A would be strongly protested by that ministry. So because of that, we retained 498A as it is, no change was made. But it was a very difficult process, because personally I had fought a case on 498A for somebody, and I had seen how difficult it is. If 498A was not there, the man who takes another wife in the lifetime of the woman, the man who does not care, the family which tortures the girl, will get away with that. It is the threat of 498A which is still acting as an antidote to dowry violence. So we continued the provision, but we issued guideline to the police that when you are arresting an accused, don't arrest family members who are in US or Ireland or somewhere. There are cases where brother-in-law, sister-in-law, everyone is implicated, so that the whole family gets terrorized by this charge, and then they come and yield to give back the dowry. Ultimately, it is a weapon to get equated in the unequal gender equation in the society, But the courts don't read it like that. Courts read it like misuse and money-making venture by women, etc. Now, coming to your second question, why there is still escalation of rape crimes? My answer is, rapes were always there. It is being reported more because there are more media channels, more local language channels, and there is a kind of social alert after the Delhi rape case. Whole conscience of the nation was shaken by this gruesome manner in which that rape was committed and reported, and because of the alert social media, etc., it is being reported. Now, third, why do men commit rape despite having such a law? They commit because it is not inefficiency of judiciary. I mean, I would say judiciary is made to look inefficient, but it is the inability of the system to cope with the number of cases for the magnitude of our country. So budgetary allocations on police, more number of police. Have you seen the number of police per people is very, very small in India. Secondly, they are not equipped technically. So thirdly, people's own awareness of their rights and police's friendly attitude towards people. The gender awareness lacking in police. You know, they are insensitive. When a woman comes with a case, I would again say it is not the same across India. In some parts of India, police are very, very active. In some parts of India, police themselves are biased. When a woman comes to report such cases, they take it casually. And also, there is a need for intermediary bodies which will bring it to the police and which will act as a pressure group. Then the cases will be booked. The main factor that I would like to share with you is the low conviction rates which happen in crimes in India. Out of 100 criminals accused who are arrested, only 18 end up in conviction. So 18% conviction is a very low rate. So criminals act with a kind of immunity, you know, that I am not going to be caught, I am not going to be punished kind of thing. The last point I would like to say, criminals being harbored by political leaders. I don't know if you have come across the media expressions of some of the leaders where they, that was again the sense of immunity, you know, that you can get away with impunity, like boys are boys, they always do wrong, these kinds of statements. That's insensitivity and ignorance of the politician or the social background. But what happens in such cases is that those who commit the crime do not face the social shame. They may end up in the prison and somebody will get them out from the prison. We had a case in Pune where Pune is the safest place, but this girl who came from United States of America, she hitchhiked a taxi, and it was a private car, but she gets into the car and then she doesn't know what happens. Luckily, while getting in, she had SMS the number of the car to somebody in US. So she is very much a Pune girl, brought up in Pune, went there, studied, then she came back and she was going to attend a seminar in the afternoon around 2 o'clock. And then finally she was found raped, and then the accused were already rape accused and they were sent under parole by the intervention of the minister of the government. So that, media highlighted that case, because of which the whole issue was brought under the scrutiny of the government. There also in Maharashtra we had coalition government, so one minister cannot be very strong. So they had to take a strict notice of this, and then they got most of them who were sent on parole to be brought back because of this one case. But then the girl had to suffer because of that. At what cost? So these are the loopholes. Since you seem to be from India, I would like to disclose these details. But I think all of you will be aware of it if you search it on the net. These issues are being openly debated. Therefore, I feel that there are many factors which show that judiciary is inefficient. Please understand, judiciary is different from executive. Judiciary has to do it according to law, according to due process of law. As much as the accused is on the wrong, judiciary has to respect the rights of the accused as well. Justice is a very, very fine balance. You cannot blacklist the accused, because under the law, accused also has got certain rights. It is not simply justice, it is justice according to law. So that is where judiciary gets caught. So please understand, so that it is the whole social responsibility, the responsibility of the system and not just the judiciary. Thank you. Yes, please.
Yes, any questions?
Yes, me also.
Yes, I'm sorry, I missed the first part of your talk, so I apologise if you've already talked about this, but the issue of female feticide and the constitutional right to life. The phrase "right to life" is often used, in the West, specifically in relation to abortion and that issue. And yet, we know that feticide is really prevalent, particularly in Punjab and so on. And it's a problem which is a middle class problem, a prosperity problem. I just wondered how the right to life in India is related, or is constitutionally related, or judicially related to this particular problem, or is it actually seen as something else, some other understanding, like an American right to life?
I got it. Thank you. Now, one thing I learned from Ireland was the utmost respect for right to life of the unborn. It is something that is very, very interesting and sacred about this country and this country's legal debates and constitutional cases. But that's not the case in India. In India, if you board a train in Mumbai, you will have statements saying abortion available for 75 rupees, kind of statements, you know. One of the reasons is we have a very aggressive campaign against family. We call it as family planning, then we called it as family welfare. There is a very strong policy emphasis on reducing the size of the family. So in the light of that, you have to read the abortion law. So if a parent chooses not to have, or parents choose not to have a family beyond 2, then it is considered as a good policy by the government, state's aggressive policy. Now that is where church and the state get into conflict in India, but church is a minority institution, so it's not visible in the public fora, in debate. But regarding female feticide, there is no coherent law that prohibits. Under the criminal procedure, under the Indian Penal Code, forceful abortion is prohibited. Very important, forceful abortion. But voluntary abortion, there is no such thing as voluntary abortion being permitted. But if you read the Medical Termination of Pregnancy Act, which was passed in the 70s, once again, the heyday of Congress, the heyday of welfarist move by Mrs. Gandhi and feminism getting into India. So the legislation passed in mid-70s. So this legislation talks about termination of pregnancy for medical reasons only. But if you read the provisions, within the reasons they have social reasons, they have physical reasons. In the social reasons, social ostracization or social shame, all these kinds of things could be interpreted. So it is not an issue which is prohibited in India. Therefore, constitutional debate on a fetus's right to live has not been there in the court. I'll tell you how the court have reacted to a connected issue, not to the exact issue, but the connected issue. We had a famous case called the air hostess case. In this case, the cabin crew who was asked to, as per the Air India was a predominant airline which was under the Government of India regulations, she was asked to, as per the rules, they were asked to retire from work, from the cabin work, after the age of 28 or after getting married, whichever is earlier. So marriage was very discriminatory in terms of their job competencies or continuing their work. So they will be shifted to some ground job after getting married or after having a child or whatever. So this was questioned. You know what the Supreme Court said? That there were 2 rationalities in this rule. Nargesh Mirza, that is the name of the case. So when it was questioned, Supreme Court said that it is not inherently discriminatory, because Supreme Court said that whenever the age of marriage is prescribed and not lowered, it acts as a policy issue of encouraging family planning. My question is, if it is family planning, then why do you control only female body? Why not the male body? Why not age for men as well? Or men's situation being prescribed in terms of marriage? Is it only female body which is reproductive or productive? So inherent discrimination in that phrase was missed by analysis, you know. But they said that we do not interfere with that part of the rule. Because even judiciary plays secondary to the policy and to the family planning idea, which is very aggressive, because everybody in India feels that controlling population is very important to become the better country. Whereas the idea of feticide as such at a social level has taken a very hard hit. In the close area of my hometown, in certain communities, male inheritance is the rule. So in those communities now, they are not finding girls to marry off their boys. So now they are from these priestly class. In priestly class, they cannot marry low castes, you know, in the conventional sense. So what they are doing now is they are going to far off areas. They are looking into other community girls who are not belonging to their community. They are giving them some kind of an initiation and converting them into priestly community and bringing them as wives. In Haryana, I was told there are no girls, so they go to Chhattisgarh area, which is a tribal area. They cross the river, get the girls from there across the boat, marry them, and the girl doesn't know where she has come from and where she has landed. So it is creating so many other social ripples. I was told in China the situation is so bad. One of our friends from UK told us that there are going to be a deficit of millions of girls for boys to marry. One-child norm has resulted in that. See the social upheaval, and this will also result in crimes. And your question on prevalence of rapes might be connected to this. That's what I would like to say. Yeah. Last question. May have had a question.
I'm a lawyer.
Professor. Maybe. Yeah, please.
Well, I think you're probably running out of time, are you?
We have time for a question from a law colleague.
Yeah. Thank you.
Okay. Well, I just wanted to mention that you had presented a very interesting picture of the rich tradition of public interest litigation and judicial activism and indeed grassroots activism, which often leads to public interest litigation. And having spent quite a considerable time here, would you like to speculate on what appears to me at least to be somewhat different situation pertaining here? We don't seem to have that level, certainly judicial activism since the 60s has tailed off somewhat in the constitutional sphere, and we definitely don't have the same level of public interest or grassroots activism.
Yeah, I would say so. Compared to US, I am ignorant of the latest trends in constitutional cases in Ireland, but at least when I stayed here, of course we had this important case, Stephen Grogan case, didn't we? Wasn't that a public interest litigation? It was a social action litigation, Stephen Grogan case. And what about this Norris case? Wasn't it? Wasn't it? I mean, it was not them. It was not their locus standi. So we had cases in Ireland as well, but these have come more from the human rights point of view, in terms of more to do with privacy, more to do with individual aspirations, rather than, of course, those individual aspirations are felt by a class of people, a particular segment of people. But in the sense of natural resources and larger public property and nature's bounty and other kinds of issues which I have debated here, it hasn't been there. But I think both have one thing in common, that these were issues beyond the people who were raising these issues, right? The Norris case changed the whole church hold on one's own choices and preferences, isn't it? So also Stephen Grogan case took that Puritanism out of the abortion debates, didn't it? That right to information put superior to the idea of much controversial idea of right to abortion. So distinguishing these things, hair-splitting distinctions in terms of protecting human rights has been a great development here as well, although it is European Union which did that, European Court of Human Rights in both the cases. But the Irish activism has been there, I wouldn't deny that. But I'm also surprised. I think inherently there is a social situation which is quite peaceful and collective thinking is there, and but I'm also surprised the way the supermarkets and others are unmindfully growing, and how was the public reacting to it. These are all some of the questions I had when I was here in the mid-90s, and today I see that it hasn't been as aggressive as it would be in Thailand or in some parts of India. It still is a very contained growth, and your concern about your ecosystem, etc., has been marvelous compared to, I mean, I saw in Dublin and I saw in Cork. It's not, may not be to the standards of Germans or the others, but still it's good. Whereas in India, these things need to be. Now our Prime Minister himself came on the street, sweeping the streets, I mean, which is a great gesture. Nobody has done it in independent India after Gandhi. So such awareness and things are required in India. That's why it's aggressive there. Thank you.
On behalf of everybody, can I simply thank Your Excellency for being with us, and particularly for Professor Gurpur for being with us and for giving such a stimulating evening for us all. Thank you very much.